back here with Dan Schorr, who's a managing director at Anchor as well. Dan, I mean, are we in serious danger of this trial ending prematurely?
It definitely could be. If he's ruled not competent to continue, then there would probably be a mistrial and he'd be held either in jail or in a mental facility until he was competent to stand trial. There's an important distinction between the insanity defense and competency to stand trial. Insanity defense is about, at the time of the alleged crime, whether he could know and appreciate what he was doing. Competency is about whether during the trial he actually can perceive events accurately in the courtroom and assist in his own defense. That's the general standard. So it doesn't matter how he was at the time of the crime. It's right now, can he perceive events clearly and assist his own defense?
The idea that he is seeing this psychiatrist who wasn't really present when he thought he was, and saying things that never really happened, how does it, would this be the standard by which one would be not mentally competent to stand trial, him laughing inappropriately? I mean, again, what we're talking about is the insanity defense. I think the defense has done a pretty good job of establishing that he has mental illnesses. But is it enough to say that he doesn't understand where he is and what's happening? Or how much does he have to appreciate of what's happening at trial?
Usually the standard is whether he can perceive enough of it accurately to assist in his own defense, which means have meaningful discussions with his lawyers about strategy, about facts that are coming in, whether he can clearly articulate things and help his lawyer. So there's two questions here. One is the things that he's saying he sees or doesn't see in the courtroom, whether that shows he's not competent, and also, is he telling the truth about that? Because sometimes people act as if they don't know what's going on in court because they don't want the trial to continue because they want a mistrial.
Now,
that happens.
I'm glad you mentioned that, because yesterday was a whole big day about whether or not he was faking the symptoms of mental illness and whether or not he was faking to get the insanity defense. That seemed to be suggested by the prosecution. Dan, I mean, the thing is, does the timeline make sense to you? I mean, all these injuries that she sustained, and she was only at Parton's house for a few minutes before Parton calls Jason Weshy and says Hannah collapsed. Or do you think that this is a result of injuries from days before?
Well, it's still unclear, and that's going to be the crux of this trial. Could injuries that have happened before at the hands of this defendant resurfaced or been exacerbated by something she did on another day? And the defendant's going to say that she wasn't in a position to cause these injuries, if they are injuries from an intentional infliction of force versus an accident. And it's really important what this pediatric ophthalmologist is saying about how these injuries were caused. He's describing them. He's going about it in a methodical way, and he'll probably reach a conclusion at the end that we assume would be consistent with the prosecution, since he's a prosecution witness.
And it should also be noted, what you're seeing right now, this is Hannah's eye that they're actually looking at. It's a really horrific case, but one of the things we got a sense of from yesterday was, at least the defense was saying, that the behavior of the father was questionable. They even seemed to be suggesting that when EMTs came to the scene, was he shaking his daughter or not? And were there more injuries caused by people that should be considered here? Was it not just from the father, but maybe when the EMTs were trying to transport her, certain injuries were caused there? You think if they raise enough of that, they could have a reasonable doubt here?
That's the goal, and it's a heartbreaking case. Obviously, we see the victim there who was killed or died through some injury at 3 years old. Now, as far as the father shaking her, there was some different wording used by the witness there. I think shaking was used first, and then that word was changed a little bit later in testimony to nudging or something less violent as shaking. So that really matters, how it's perceived by the jury and how it's described.
Dan, what are we supposed to make of this? Again, and there's a witness who's being qualified right now. We'll jump in when there's something going on, but what do you make of this right now, this back and forth between the prosecution?
Well, certainly the medical testimony is going to be very important here, because they're going to document what injuries there were and how those injuries could have been caused. So if, as the prosecution says, these are blunt force trauma or other physical wounds that wouldn't be from stumbling or falling that a normal 3-year-old engages in, that's going to be inconsistent with what the defendant is trying to say.
That's what the prosecution has shown so far. From the injuries that we saw, we got a really good indication from yesterday. It appears the injuries are not from falling. So that's not good for the defense.
Right. Then the other defense they could give is that someone else caused these injuries other than this defendant. But the story that it might have been an accident, that she just fell, that seems to be inconsistent with what so far has been reliable medical testimony, that there was some kind of intentional infliction of injury on this girl by someone. The prosecution saying it's by the defendant.
Okay, so this is Dr. Michael Young. We're about to hear some of this testimony. Dan, what can we expect?
Well, first of all, they're establishing him as a very experienced person. He said he used to see 2,500 to 3,000 patients a year. So when he gives his conclusion at the end, which, because he's a prosecution witness, you assume it'll be consistent with their theory of the case, that would be pretty powerful if he has the experience and he can clearly show these injuries were caused by someone intentionally, wasn't an accidental fall.
And I wonder, the defense is doing two battles here. One saying, is this even child abuse? Could this also be from, injury sustained by falling? Or if it is in fact child abuse, perhaps it's from someone not at the hands of Lindsay Parton, but somebody else. Because again, if she was brought to if Hannah was brought to her house and then only a few minutes later she collapses, it would make more sense that injuries happened beforehand. Well, Dan, that's what we were waiting for, the main conclusion. He believes this is abuse. What do you make of it?
Well, that's really significant. He comes off in a very credible way. He has a lot of authority. He has a lot of experience. And he said abusive head trauma caused this injury. Now, the defense can either dispute that with other expert testimony, or they could say the abusive head trauma was caused by somebody else. But it certainly seems it won't fly for the defense to just say this girl fell and it was an accident.
That's a good point. It seems hard for them to argue this was an accident and she fell. Why didn't they center their attention on other people who might have done this as opposed to the defendant? Because it seems their best argument is that this girl was in her care and custody for only a few minutes before she calls the girl's father. Why not capitalize on that? Couldn't this flip on them in the sense they tell the jury, well, it might be from a fall, but wait, maybe it's somebody else. I mean, they can't go too many ways.
That's a good point, but if you look at it from the defense perspective, let's say they're telling the truth. Let's say she really did just receive this girl and she doesn't know how she got injured. Then she might say, oh, I remember she did fall yesterday, but maybe she was with somebody else. And she may not really know what the answer is for who caused the injury if the defense is telling the truth. So that's why they may be speculating about different things.
The defense attorney in this case in opening statement said this, the evidence will show that Hannah's father brought her into the garage with a blanket over her head and her coat hood up, handed her to Parton, and he left. And within 30 seconds, a minute, she's calling him, the child is unconscious. If that's true, that's odd. I mean, why would he deliver his child in that way?
Right, if that's true, and if there wasn't enough time for this defendant to cause abusive head trauma in that time period after receiving this girl from her father, then that would be good for the defense in terms of establishing at least reasonable doubt. So we may hear the father testify about what really happened when he delivered his girl to this defendant.
One thing to note, we believe that Lindsay Parton, the defendant, is going to take the stand and testify. What do you think that'll be like?
That's going to be the key part of this case because she's going to have to give a version of events that's believable to the jury. She'll be cross-examined about how these injuries might have been caused, and that's always difficult for any defendant. But it might make sense in a case like this where she has to give some version of events, unless, and sometimes they say someone's going to testify, and then they don't testify if the defense feels they've made out reasonable doubt through just going after other witnesses. So we don't know if she's going to testify, but it would certainly be very interesting and very important for this case, obviously.
What's the best scenario for her testifying? I mean, what would be the thing? Let me use a standard now. What would be the James Scandarito version of testifying? Because I'm referencing, he took the stand and he got off for murder. But here, what would be the best thing for her to articulate on the stand?
Well, first of all, she'd want to testify about how she took care of this girl, how she babysat for her, how she loved her, how she would never hurt her, and she needs to do that in a credible way. And then try to talk about the time period that she was with her, and that it doesn't match up with these supposed intentional injuries that this doctor and other witnesses are going to be talking about. And that's up for the jury to believe. Look, this is a tragic case.
It absolutely is.
This doctor who just testified talked about there was actual trauma to this girl. So somehow, in a non-accidental way, she was killed if this medical testimony is to be believed. So the defense has to say this was someone else who did it.
And look, this is another day of testimony explaining that these injuries are no accident. Let's go back live into court. Okay, so what did you make of right now where we're in the second chapter of this testimony?
Right, well, so the defense lawyer is trying to show that there's other medical testimony, even from the prosecution, that's inconsistent with this witness's testimony. And this witness correctly said, I'm not aware of other witnesses' testimony. I can only talk to you about what I can testify about, which is proper because a witness isn't supposed to be evaluating other people's testimony usually. So the defense is obviously going to flesh this out. They just presented the coroner's report, and they'll probably try to show there's inconsistent medical conclusions about the injuries here, but we'll see how credible that is the way they develop it.
And where do you think the defense would go with their witnesses, besides calling the defendant, who we see there, that's a live feed right there of the defendant in court? I mean, what kind of witnesses should they call?
they might want to call an expert of their own who can look at the retina scan and other medical records and say that they would draw a different expert conclusion about whether this was intentionally inflicted abuse or whether it could be caused by an accident. And remember, they just have to show reasonable doubt. So even if an expert witness on the defense says it's possible that it was an accident, that may be enough for reasonable doubt. Maybe they'll do that.
Yeah, and these idea of two different falls that Hannah might have, she might have one 2 days before, one the day before, two different ways. A fall can be pretty traumatic, but this level of injuries, that's a different question. Or could it be a combination? Falls and maybe something else?
Well, look, 3-year-olds fall all the time. That's just their normal life. They fall, they run, they climb, they fall. So they're always falling. The question is, would a normal 3-year-old's falls amount to this type of injuries? According to this doctor, the answer is no.
And she's been charged with involuntary manslaughter, murder, and 3 counts of child endangerment. What do you make of those charges?
Well, those are the appropriate charges. Obviously, the top count is really the serious charge. The endangering counts, there's not going to be consecutive time because it's really one action or one series of actions against this victim here. So the defendant, though, is facing a tremendous amount of prison time if she's convicted.
Yeah, I want to analyze those charges a little bit because it might not be exactly what people are thinking about, especially in terms of the murder charge and how it connects. But this is a very serious case where we're trying to understand exactly what happened. It's also fascinating to see the defendant in court waiting because this is a really big moment for the defense. We're going to take a break. Okay, let's break down what's happening right now. Again, I'm here with Dan Schorr, who's also a managing director at Ankara. Dan, defense has some work to do here. I mean, this witness, who's highly qualified, it appears to be, said that in his opinion, it appears to be, abusive head trauma. That's his diagnosis. What are they trying to dissect here? What are they trying to make the point of?
Well, one key thing they're doing, which is a good tactic against any expert, is to say you didn't review everything because it's very hard to review every single document. So he's saying, I believe it was 4,500 pages of medical records. And he's saying, well, you didn't review it all. Why is that important? Because then in closing arguments, he could say, look, he gave his opinion, but he didn't even review all the records. And this is a common tactic. It's hard to, as they say, out-expert an expert. If you're an expert at something, I can't really convince you that you're wrong because you're the expert and I'm just a lawyer, but I can say, hey, you didn't review everything, so therefore your conclusion is faulty.
Are they also saying that he's making statements today in court that are not in the report?
Right, he's going beyond his report. And again, that's typical. You don't write down every single thought in a report because it's hard to contain your full analysis, but you try to document as much as possible. So he could say, you're changing your story a little bit, you didn't review everything. And again, as we keep saying, they're trying to establish reasonable doubt. So they could say, look, you can't conclude beyond a reasonable doubt that it's intentional force just because this doctor who didn't review everything and changed some of his, or didn't include all of his conclusions in writing.
Now, Dan, I want to just break down what the defense is doing here. Are they also getting the sense that, yes, he provided opinions today, but it's kind of limited in what his opinions were? I mean, really, the crux of his testimony was about the eye.
Right. He's talking about there was abusive head trauma that caused the injuries to the eye. And one of the defense points is that we don't know what kind of abuse led to that abusive head trauma. Could have been shaking, could have been a strike, blunt force trauma. And the witness is acknowledging, yeah, I don't know how it was necessarily caused, but I know that it was some kind of abusive trauma, which isn't an accidental fall. So the defense is saying, well, that's not really clear. Certainly that'll be part of their argument that we don't know how these injuries are called. But sometimes that's the nature of injuries, that you could tell it's not through an accident, that some kind of intentional act had to have caused these injuries, but we don't know exactly what intentional act that was.
You would think a case where a babysitter is on trial for the death of a 3-year-old that was in her care would seem pretty straightforward and a pretty easy case to prove. But is this an easy case for the prosecution?
No, these cases are difficult. I've seen these cases when I was in the DA's office, and they're difficult because you don't know exactly how the injury was caused, especially if the only person there besides the deceased child is giving one version of events that's maybe inconsistent with the evidence. But then how do you show what actually did happen? If someone says, well, there was an accidental fall, or I have no idea how this injury was caused, and yet there's abusive head trauma according to the doctor, if no one else was witnessing it, how do you show what actually caused these injuries?
Especially since the defense will also be casting the blame out on other people, including, it seems, the father. I mean, why was he bringing his daughter to Parton with a blanket over her head and a hood? Seems a little suspicious.
Right, and that's how these cases proceed, that the defendant usually says, I didn't cause these injuries. I don't know how they were caused. It was either maybe an accident, maybe someone else did it, but I didn't intentionally cause these injuries.
Dan, one of the things that I'm going to be waiting for is what the prosecution mentioned in their opening statement, that the defendant allegedly gave inconsistent statements to law enforcement. In fact, they claim that she at one point said that she admitted to uppercutting Hannah multiple times and poking her in the chest. The defense is saying she never injured Hannah. What's going on?
Well, if they can actually prove that she made these inconsistent statements, that's going to be a real key part of showing consciousness of guilt. Why would you make inconsistent statements if you weren't guilty? There's also been public reports, excuse me, about maybe the girl here threw ketchup into a toilet, and that it motivated the defense to get angry. That hasn't been put into evidence in any way, but there were some public reports about that.
Right.
So will that come into evidence? How do you establish that motive?
But if that comes forward, if this evidence comes forward, you have law enforcement officers saying, well, you know, the defendant told me X, Y, and Z, and she made this comment on this date. What is the defense attorney supposed to do? Saying, well, you know, she never, when we say uppercut and we say poke, she might have, it was a gentle slap or it was a gentle, is that a way to explain it? I mean, because they never, I'm not sure if they ever said she never hit her, but they said she never injured Hannah. Now, I'm not sure the exact terminology, but maybe that's a way.
That's why the words matter, how it comes into testimony, the reliability of the person who says that she said that. Is that person who's reliable? Can the defense say, well, we never really said that, she never said that? Or do they have to say, well, she said that, but she didn't mean that? Or maybe the words weren't recorded accurately, reported accurately. So we'll have to see what the words are. But certainly if she made statements that she intentionally took actions that might have caused these injuries, that's a major problem for the defendant. But we haven't seen that yet, and the defense will then decide how to dispute it.
Right, and look, the defense is saying that, you know, she's completely innocent. This was maybe a result of falls that happened. You know, all these kinds of evidence, and also that she told the Jason Weshy, this is again the victim's father, about the falls that she sustained and the injuries, saying that she was just doing what a normal babysitter should do. As we listen to the testimony of these experts, Dan, the thing that gets to me is the idea here that I think this case is just a battle of experts, right?
Yeah.
Which side will the jury believe? We see that a lot in other kinds of cases, maybe even the insanity case, but this one is all determining about the injuries. This is so injury specific.
It's not entirely a battle of experts. It's definitely a big part of it, because there's the question of, were these injuries based on intentional force or were they based on an accident? That's one part of it. And then if it was intentional force, who caused it? And that's less of a battle of the experts. Was it this defendant? Was it the girl's father? Was it somebody else? So there's two parts of this case. How were the injuries caused, intentionally or not? And if intentionally, who caused them? And certainly the part about whether intentional or not, that's a battle of experts. We saw that with the cross-examination of the last doctor, and I'm sure we'll see that after this, and you'll probably see at least one defense expert. We
keep saying that what the defense is arguing is that Hannah fell, right? I want to just make sure we're clear here. What the defense said in their opening statement is that Hannah took a face plant onto the ground. This was 2 days before she ultimately died. The next day, this is a day before she collapsed, is that Hannah was standing on a toy train and she fell hard. And then it's been alleged that the defendant told Hannah's father about the injuries as well. These seem to be pretty serious injuries, so I can imagine the defense bringing their own kind of experts will be a big move for them.
Yeah, there will be at least one defense expert, and the cross-examination of the last doctor showed that they were focusing on a bruise on the back of her head, that they said the notes from that witness for the prosecution did not observe, and maybe they're going to show that that bruise was with the cause of the death that the prosecution overlooked that, or the doctors who were being called by the prosecution overlooked that. So it's going to be, well, what injury was the cause of death? What was not the cause of death, and maybe just another bruise? Children have bruises. Usually they're not life-threatening. So there might be bruises here like almost every young child has from running around that aren't part of what caused her death.
All right, Dan, according to her, Hannah suffered abusive head trauma. She wouldn't have been acting normally. The symptoms of this would have occurred pretty soon after the injuries. This is a blow to the defense.
Absolutely. This is powerful testimony. And also when you view it with the other experts that are testifying for the prosecution, it's really a clear case that these injuries that this girl suffered are not accidental injuries just from a fall here or a fall there, that there had to be some kind of abusive trauma. Was that from shaking? Was that from intentional blows against her? That's unclear, but certainly the idea that she was just playing around and fell and then died, that seems to be not credible when you hear all these prosecution witnesses, if they're believed, and they do come across very knowledgeable, very experienced, very persuasive.
All right, so we've seen throughout this case that the cross-examination is getting a little heated at times, but the timeline's important here, right, Dan? I mean, when did she receive the injuries? When was she exhibiting symptoms of not acting normally?
Right.
Because if you believe the defense, she was brought over to Parton's house, and a minute later she collapses. So what do you make of everything that we just saw?
Right, just she's saying that if this injury happened a while ago, the girl wouldn't have been normal for that amount of time. And the defense is going after her saying, well, you're talking about the timeline being important, but you don't have all the details in your knowledge, such as 911 call time, other details. And as we talked about before, that's a common tack to go after experts, because often in a case they've reviewed their own expert analysis, but they haven't reviewed all the police reports. They don't know the details of every witness testifying. So you could say to them as a cross-examiner, hey, you don't know this, you don't know that, you haven't reviewed everything. And then you could argue to the jury, look, this person is basing their conclusions on incomplete information, so therefore don't believe it.
They also went after her past. They took out a transcript from an old case where she testified where that time frame between the injury and the symptoms wasn't as precise as she had just explained. And then she finally concluded, if I'm understanding her testimony correctly, that just looking at the brain scans, she couldn't tell the timing of the injury. Let's just get into the charges here. They're a little different than what people would expect, especially the murder charge. Can you help elaborate? She's charged with murder, involuntary manslaughter, and 3 counts of what you could call child endangerment.
Right, and the murder charge is not intentional murder, so they're not alleging that she intended to kill this girl. They're saying that she committed some other violent felony, endangering, and that violence led to the death, that it was a proximate cause, led to the death, and that's why it's murder. It's almost kind of felony murder case. So they're not saying that this babysitter intentionally killed this victim here, but that her intentional violent acts led to the death.
In other words, the defense's only option is to say that she never laid a hand on this girl, that this was a complete accident, or somebody else hurt this girl.
Or that she did lay a hand on her, what she did physically did not lead to the death, that there was some other intervening act, someone else took an action, or some other fall that led to her dying, but that her physical actions, even if intentional, although I'm sure she'll not say there's no intentional act, it didn't lead to her death.
Dan, one more question. I know our time together is coming to an end. What kind of jury would you want if you were the defense attorney?
Well, you want a jury that's going to be skeptical of experts, people who may not just believe what they're told, people who may think outside the box. I think someone who's just going to hear experts and believe them is going to be likely to reach a conclusion favorable to the prosecution. And you want at least one juror to have a doubt about what the experts are trying to convince the jury of.
Dan Schorr, Law and Crime legal analyst and managing director at Anchor. Thanks so much for coming on.
It's always great talking with you, Jesse.